Welcome, everyone. Thank you so much for joining us. My name is Modirzadeh. I'm the director of the Harvard Law School program on international law and armed conflict. And it's my real pleasure today to welcome Professor Leonard Rubenstein of Johns Hopkins University, Bloomberg School of Public Health, who I'll introduce more thoroughly in a moment, who is here to participate in a book event we're having on the event of the publication of his book, Perilous Medicine, The Struggle to Protect Healthcare from the Violence of War. I have my own copy right here and encourage you to get your own. We're going to be taking a few moments for introductions, and then we'll dive right into the substance of the book. So we'll do a bit of scene setting for those who haven't seen the book yet, just on what the main subject matter is and why Professor Rubenstein decided to undertake writing this book. Then we'll go into some more substantive questions and talk about some of the recommendations that come in the final chapter of the book. And then we'll have a few minutes for questions and answers. Please feel free to use the chat to communicate with us if you are having any technical difficulties or if you are having any questions. Use the chat box and you'll be able to communicate directly with us. And if you have any questions that you would like me to pose to Professor Rubenstein, please feel free to use either the chat or the Q&A box at the bottom of your Zoom screen, and I will keep all of those with me for purposes of the discussion at the end of our time together. I know that we have a lot of students who are joining us and that your classes start up promptly at the hour 1:30, so we will jump right into the material. Let me briefly introduce our speaker, and then I'll say a word about the book, and then I'll turn it over to you, Professor Rubenstein. Leonard Rubenstein, who is an HLS grad, is the professor of practice at the Johns Hopkins Bloomberg School of Public Health and director of its program in human rights, health, and conflict. He is also a core faculty member at the Berman Institute of Bioethics and the Center for Humanitarian Health at Johns Hopkins. Prior to coming to Johns Hopkins in 2009, he was a Jennings Randolph Senior Fellow at the U.S. Institute of Peace. And before that, and in a way that really enriches this book tremendously, he was executive director and then president of Physicians for Human Rights. Len is the recipient of numerous awards, including the Congressional Minority Caucus Healthcare Hero Award and the Saida Levy Award for Peace of the American Public Health Association. He has appeared before Congress, the World Health Assembly, and the UN Security Council. And I will say those of us, particularly Dustin Lewis, our research director, and myself, have really been so lucky to be able to collaborate with Professor Rubenstein in our own work on medical care and armed conflict. Len, I'd like to turn to you to just tell us a bit of introductory material about the book and why you wrote it. But I just want to add one personal note. I think one of the things that is most urgent and most important about this book, in addition to all the incredible analysis that you provide, is that it really gives us a human account of the costs of war and particularly the cost of attacks on healthcare. For those of us who approach these issues from the perspective of international law, I think there is sometimes a sense in which many of the rules and their interpretations can feel incredibly abstracted out and removed from the human beings that these debates are meant to relate to and that these rules are meant to protect. And I think your book is crucial for lawyers in particular to read because it really gives a sense of why these debates matter so very much to people that are caught up in armed conflict. So with that, let me ask you, can you tell us a little bit about the book and tell us what inspired you to write this book?
Sorry, all these months of Zoom and I was still muted. First, thank you so much for having me for a number of reasons. First, Naz and Dustin and others at the program have done so important work relating to the law of protection of healthcare in conflict. And I relied heavily on that work. Secondly, I'm used to speaking to public health types now, but as a lawyer and because the law is so important, it's really a privilege to speak to all of you. I wrote the book for a few reasons. One, and the really overwhelming reason, was that the problem of violence against healthcare in conflict is enormous, and with tremendous and devastating effects. Just to give you one little piece of data or data point, between 2016 and 2020, there are more than 4,000 recorded incidents of violence against healthcare in conflicts around the world. And that certainly is underreported. But when you break down that number, that 4,000 number, what it amounts to is that every other day, a health facility is damaged or destroyed, and every third day, a health worker is killed. And this violence is taking place in countries that often have the worst health systems, the weakest health systems. They have the worst health indicators. And what this leads to is not only harms from the killings and destruction in the moment, but long-term effects on emergency care in childbirth and vaccination for children. In fact, polio was supposed to have been eradicated 20 years ago, but it's still around because it's endemic in Pakistan and Afghanistan, largely because vaccinators are being killed when they try to immunize children. So I wanted to bring attention to this issue, which certainly doesn't get enough attention in the global health field. It's an incredible outlier in that field. Second is about the law and the norms. It's a real paradox, I think, that the norms of protection of healthcare in conflict are about the oldest norms in the law relating to protection of civilians or combatants, and the regulation through international treaty of the conduct of war. They go back to 1864, and ever since, the law has gotten stronger in 1949, and then again in 1977, in the extent of these protections. And yet, not only do we see violations, but we see what I consider kind of subterranean norms that are rarely, though sometimes, articulated, but seem to me to have an enormous impact on the way combatants behave. And that can explain some of the violence. But because they're unacknowledged, except in occasional ways, we don't have a real discussion about those competing norms. And I wanted to surface that difference and try to help restore the norms that seem so well accepted around the world, but are so frequently violated. So the book was trying to develop a framework to explain how those competing norms play out. And I'll just spend a moment explaining what those norms are. The Geneva Conventions are based on the principle of humanity, which say that a wounded or sick person, whether a combatant or a civilian, should be treated as a human being, and you should try to reduce their suffering. It's related to principles of justice, but of course, recognizing that they're human beings. And that led to the strength of the protections. In 1864, in the first Geneva Convention, it was the only protection. It was exclusively concerned with the wounded and sick. The competing norm, ironically, was advanced in the same decade, in the 1860s, as the Geneva Convention was adopted. And it was propounded by a theorist named Francis Lieber, who was a major intellectual of that era and was very interested in the conduct of war, as well as the justification for going to war. He thought the two were interconnected. And he actually ended up writing the first code for US military forces just before the Battle of Gettysburg in the Civil War. And his thinking was very different from the thinking of Henri Dunant, the father of the Geneva Convention. Lieber thought that there were limitations to conduct in war and that there were moral principles at stake. But there were limits to the applicability of those norms. So he was against gratuitous cruelty, like execution of prisoners or torture, or gratuitous attacks on civilians. But the word gratuitous is important because if the violence had a military purpose, then it could be justified to end a war more quickly. And he incorporated that idea into his code. It was his idea of military necessity. So, for example, he said that hospitals should be protected to the extent of the contingencies of the battle permitted. And that's an incredibly open-ended standard. And what is important to understand is his view was rejected as the law developed. In fact, his ideas of collateral civilian harm became narrowed ever more as the conventions evolved. But in my work, both in human rights reports when I was at Physicians for Human Rights and in my research at Johns Hopkins, around the world, whether it was Myanmar or Afghanistan or Syria or Yemen or many other places, it started to appear to me that it was the Lieber norms that combatants were following. So I'll stop there and I can go on and give examples if you'd like.
Yeah, so actually, I'll pick up right there to ask my first question. I think this framing is fascinating, and it's not one that I think we often talk about in the context of IHL, or at least not the kind of mainstream narrative of IHL. Lieber is in some ways folded into the progressive narrative of the development of the rules and is seen as having sort of introduced some of the early versions of the rules. Can you tell us more how you see these competing norms playing out in the present day? So particularly in the book, you talk about that there are contemporary justifications for attacks on hospitals, for attacks on medical care individuals and facilities. How do you see that early legacy of two different ways of seeing the role for this protection in armed conflict carrying through to contemporary conflicts?
I think the clearest case is with respect to treatment of enemies, medical care for enemies. The convention at the very beginning required impartiality in care. Basically, that an enemy was entitled to the same care as your own ally or your own troops. And that is carried over to civilians, whether civilians were allied in some ways or loyal in some ways to the other side. The Geneva Conventions, as a bedrock principle, say there is equal treatment, impartial treatment based on medical condition alone, not based on their allegiances or even their actions. And that's bedrock, and it's consistent with medical ethics. It's a very core principle of medical ethics that you act impartially. You don't care about the political views of your patient, and you must, especially in an emergency, which is what these situations are, you must provide care. That is under siege. That view is under siege. Wherever I looked around the world, I saw that doctors were being punished for treating people deemed as enemies. And we see this especially now in Western governments, including the United States, as in counterterrorism law, where the idea of impartial care is eliminated based on who the person is. Therefore, the laws dehumanize people deemed terrorists, that they are not to be provided care, and anybody who provides that care can be subjected to criminal prosecution. In US law, material support includes treatment. So that's one example of how the Lieberesque approach, which would say, well, you may not have to treat enemies because they might get back into the fight, or they may commit a hostile act in the future. So you can deny care to enemies, even though Lieber was very strong that you shouldn't kill them when they're wounded. But he allowed this kind of thinking, and we see this in contemporary law and practice.
Len, let me ask you before we go back into the law. There was you discussed something which was new to me, perhaps not to those who study public health or the history of medicine. That the very idea of a kind of imposed impartiality on the medical profession was itself at a certain point controversial. And you talk in the book about the fact that, for example, in the US, there was long resistance from the professional medical community itself to being a requirement of impartiality based on the resistance to being forced to provide medical care to Black Americans and others that doctors and medical professionals may not have wanted to treat. Can you tell us a bit how this idea of impartiality has evolved in the medical profession and how it's seen today?
It is a very interesting story. There was and still is a provision in medical ethics that says that physicians can choose which patients to take on. They don't have a gastroenterologist doesn't have to take on a person with an eye injury, or for many other reasons, they can decline to serve a particular patient. But the way that played out, and the reason it survived in such a very strict form, was because of racism in the professions. And it was not until the civil rights movement that the idea that this kind of rejection of patients would be forbidden. And over the last 60 years, that has become a core principle. And it's been incorporated not only as to race, but gender and LGBTQ status or ethnicity or any other kind of civil rights-based criterion. So that has become a core principle, and it's become a principle related to counterterrorism as well. That there was a recent symposium within the last decade in a bioethics journal about whether a Palestinian terrorist who was arrested after bombing Israeli civilians was entitled to treatment. And even though there was some disagreement about how much money should be spent on the terrorist who, in the hypothetical, needed a year's worth of treatment in a hospital, there was agreement that there was no basis not to treat the person. So that has evolved. Interestingly, it took a much longer time for the medical community to adopt impartiality as a core principle than it did for international law. But now it is embedded, and you see it in ethical codes, including in codes relating to armed conflict.
That's really, really fascinating. And I think a history that it's important for those working on these issues now to be aware of. Let me ask a follow-up to that question. I think part of what you do in the book that is interesting and in many ways different from legal accounts of this issue or exclusively legal accounts is you remind the reader that this conversation about a quote unquote new normal in a way creates a fiction about a past when these rules were clearly applied and respected, and gives this impression that some of the attacks that make front page news today, Kunduz or Saudi Arabian strikes against medical facilities in Yemen, are somehow aberrations or anomalies or a new development. Can I ask, how do you grapple with making an argument in favor of further legal protection or further respect for IHL, while also in a way being honest about the fact that there really is no golden age of IHL to be referred back to here. How do you see the question of strategically framing a narrative about IHL in light of the current challenges when, as you say, this is a long-standing track record of disrespect for and indeed direct attacks on the medical profession and on medical facilities?
I think it is important to recognize that there wasn't a golden age. People act as though there was, but going back to the Franco-Prussian War and World War I and the attacks on hospitals during the Ethiopian War in the 1930s and World War II and Korea and Vietnam and El Salvador and Mozambique, the record is terrible. But it shouldn't breed cynicism, because despite what I found around the world and the number of violations of IHL, it may seem paradoxical for me to say IHL has made a huge difference. If you look at strategic bombing in World War II, and of course, including the incendiary bombing in Germany and Japan, the use of napalm and strategic bombing in Korea, which leveled 18 cities in North Korea, probably destroyed 1,000 hospitals. That era has mostly ended. That instead of 1 million people or hundreds of thousands of people being killed, the change of norms and values, not only because of IHL, but certainly by the contribution of IHL in 1977, when indiscriminate attacks were outlawed, we've seen a major change in practice. So that in the Kunduz attack or in casualties in the war against ISIS, where Raqqa and Mosul were leveled, you see civilian casualties in the low thousands, maybe 10,000. And that is terrible. Those shouldn't happen. But the scale is so much lower. It's orders of magnitude lower than Vietnam, where you're talking about hundreds of thousands and maybe millions of people killed from indiscriminate use of force. So despite what I see, I'm still a believer that international law makes a huge difference. We just have to strengthen commitments to it and recognize what the challenges to it are and get some leadership in addressing them.
And in a way, it sounds to me like part of your argument is both if we are honest about the fact that there was never a golden age, but also if we are honest about this Lieber strand, right? This argument that, and you illuminate a number of scholars even today making this argument that a kind of ends justifies the means argument. It strikes me that in a way you're also saying IHL that protects medical care and indeed mandates it in some cases has always been framed in resistance to a very different conception of medical care. It already takes account of the counter argument. And so it isn't this kind of naive commitment to humanitarianism, but rather it's really, its mettle has been tested, if you will, in the battles over how IHL would be shaped over all this time.
Yes, indeed. And there are, the protection of healthcare is about as close to absolute as any provisions of the Geneva Conventions. But it's not absolute, because if a hospital is used to store weapons or uses a firing spot, it loses protection. It's similar with combatants. If you're wounded and you're trying to still kill people with your gun, you're not protected. So it does take that into account. But I think that we don't need to change the rules. What we need to do is surface the subterranean rules and deal with them. And there's one other dimension in the evolution of IHL. As I mentioned, there are now not only rules about not attacking, but taking affirmative steps to protect. That is, in no indiscriminate attacks, and making sure that attacks are proportional and taking precautions in attacks. And what we see, and we saw this in the Saudi war on Yemen, that the Saudis simply declined to take those steps. They didn't target properly. They engaged in strikes based on inaccurate information from spotters on the ground while the planes were flying around looking for a target. And it was inconvenient, and the Saudis were simply reckless. So what happens there is that it was showing a kind of contempt for the precautions required. And there was another dimension too, we haven't talked about that yet, which has to do with the complicity of the arms sellers in that work. So we have a lot of work to do, but I think that in general, the law is quite sensible, and we have plenty of examples, even today, where searches of hospitals are conducted properly, where checkpoints are operated so wounded people and pregnant women can get through. And we have the mechanisms to make sure healthcare can be safe.
So let me ask, and I'll invite you to sort of use whichever, you have so many rich examples and case studies in the book, so I'll invite you to use whichever you think is most illuminating for this purpose. But I'm wondering, you are very candid in articulating some of the arguments that have been put forward by a range of different kinds of states and actors, historically and in the contemporary context, that raise questions about these near absolute legal protections and say, well, in the following cases, it's just far too dangerous to provide those protections, or it's far too dangerous to allow medical facilities to treat these particular kinds of individuals. How do you envision that one could reignite a politics and a popular debate over this question at a moment when I think many might say the risk of a public debate and a political engagement with this question is that members of the public in various countries might actually say, let's make these rules less protective. Let's do more to catch terrorists or make sure that this particular armed groups doesn't get access to care. How do you see this in the contemporary political context as an issue? I read your book as in some ways saying this has to be something that is discussed and debated in the arena of politics, not only amongst a handful of international lawyers or as between the military and the medical profession. How do you see that happening?
You're absolutely right that the politics is a solution. And we haven't seen much of a discussion in the political arena. It still is seen as this technical issue in the law. And unfortunately, in the public health community, the issue is subordinated to so many other questions. I think when people see the consequences of violations, they understand what's going on. For example, I mentioned Yemen. The Saudis destroyed the water infrastructure in Yemen, and it resulted in the largest cholera epidemic the world has ever seen, 2 million cases, which is like 20 or 30 times what's in second place. And when people understand what the consequences are, the deaths of children from measles because they can't get vaccinated, or the continuation of polio, I think if that kind of discussion came into the political arena, we can make a lot more progress. And that in some ways is what my book is trying to do. At the same time, it's not pie in the sky to say that these protections can be accomplished. I use the example of the Israeli-Palestinian conflict because it's a principal case where people say that the Geneva Conventions are obsolete because it's urban warfare, it's a conventional, powerful military against an insurgent type group that doesn't wear uniforms, doesn't obey the rules at all, uses civilians as human shields, fires from rockets from residential areas, that the Geneva Conventions really are irrelevant. So I devote a lot of attention to the violence inflicted in medical evacuation of Palestinians over the last 20 years. And many, many medics have been killed. Many people have died because they couldn't reach a hospital for emergency care or safe childbirth. And going back, there was a time in 2002 during the Second Intifada when many medics were being killed, and there was a lot of political pressure on the Israeli military, plus a lot of unhappiness within the command structure that ambulances were being attacked and medics were being attacked, and there was a major reform. And that worked for years, it worked. But then the politics in Israel changed, attacks on human rights groups increased, they were marginalized, the government became more right-wing, and the rules of engagement were loosened in practice, if not in theory, in the wars in Gaza over the last 10 years. And once again, we saw violations. And what more than violations, you saw many people die as a result. Sometimes 3 days would go by before an ambulance was allowed to go in and rescue injured civilians. So it is a political issue. And the evidence to me is that when the politics are right, we can not only secure compliance, but secure compliance in a way that allows militaries to fight in circumstances that present a lot of tactical and strategic difficulties.
And do you see the politics of the debate? So in a way, if I can ask you, how do you deal with it when the politics are wrong? So what's the approach when you are talking about protections for individuals who are incredibly unsympathetic? And you have a number of cases, including one in Boston in your book. Does IHL provide a basis for a kind of a political strategy around this issue, or do you see it as being a more pragmatic argument about saying if these types of individuals are not protected, then sort of the broader infrastructure of protection is threatened? I'd be very interested to hear how you think about what an effective political narrative around this story looks like today.
I think what we need to do is expand the constituencies, which are now so narrow. The constituencies now are humanitarian organizations, and it's and the IHL community. That doesn't work beyond getting some resolutions at UN agencies that aren't complied with. What we need is some movement to raise the stakes, not only to say IHL is important, but the preservation of healthcare is important and people's lives are at stake. And one of the things that's so striking, and I keep coming back to this, is the health community, medical groups, nursing groups, public health groups, global health groups have been relatively silent, not because they think it's okay, but because it's not a priority. And health ministries and health agencies have to speak out. And we've seen some really great leadership from some unexpected places. I have a little profile of the Minister of Health in the Central African Republic, which is an incredibly poor country with a terrible war going on with more than a dozen armed groups. But he has made this a priority. And his priority is help increased protection. And he's gotten support for his work in many forums. So I think the politics is really about increasing awareness of the problem and then organizing constituencies that care. And I think we have an example in journalism where we know the Nobel Prize was given to some journalists this year. Now, why was that? Well, one thing is because they were heroic and courageous, but also because the journalism community has made such a big effort to release captured journalists, to have solidarity with their colleagues. We don't have that. We don't have solidarity with the thousands of Syrian physicians who've been arrested or killed in Syria. We don't have that solidarity. We need that. I think that's to me the political answer.
Yeah, and I think you raise at the end of the book a really fascinating proposal for, as I read it, a kind of solidarity between the medical and legal professions, that there is room here for a kind of a politics of solidarity between professions that see themselves as invested in admittedly different kinds of protection, but protection that really converges when we're talking about healthcare in war, which of course would also include those who are active in seeking to prevent war, right? For peace activists as well, it would seem fall within your umbrella of those that would be in a natural kind of solidarity with the medical profession when it comes to the question of the impact of war on healthcare. Let me ask a question, a bit of a diversion, but one that I wanted to make sure to include. You talk a little bit in the book, and I know you've been exceptionally active and you've been a leader in the area of enhancing and establishing methods by which the World Health Organization and other actors can track and create reliable data on attacks on healthcare in armed conflict and the perilous nature of much of the provision of healthcare in armed conflict. Can you talk to us a bit, tell us the story of doing that, and can you tell us, particularly for a legal audience, why do facts like this matter for how we understand compliance with the law, for how we understand arguments rooted in international law? Why is this something that you've seen as so important?
Well, I'll start with the discussion we had a few minutes ago about the new normal, about how there used to be this time when there was compliance and now there isn't. And the reason people think that is that in the old days, we didn't have very good data. We had these spectacular incidents during wars, like the strategic bombing and other examples of attacks on hospitals. And without knowledge of what's going on, it's almost impossible to gain any kind of political momentum. There is a nice phrase in public health that says, "What gets measured gets done." So, and we do that when we evaluate programs. How effective is the program? We see that in COVID, where the effectiveness of vaccines has been the leading argument for more people getting vaccinated, putting aside, all the resistance, but that's the fundamental public health answer, that we've shown that this works. We've measured it, we've evaluated it. So that's really important. And what is remarkable is that until 10 years ago, there wasn't even any effort to determine the scope of this problem. We had some anecdotes here and there, usually very few and far between. So when we started advocating on this, and there was a coalition I was involved in starting 10 years ago, to say the grounding of the work has to be in data. Data doesn't necessarily drive decision, but it's a prerequisite for the political work that can use it to build that momentum. So there was a push to say that the World Health Organization has to collect this data. A resolution was passed in 2012. The WHO still resisted. It then finally started. Even now, its methodology and its commitment is somewhat problematic. It underreports, but there is now investment by a larger community of nations to collect this data, even though there's been pushback. Russia has pushed back on collecting data, and there's a lot of politics about this. But we need that data. And for example, I cited at the very beginning the 4,000 number over 5 years. When you talk like that, people may pay attention, and then you can go into the law and you can go into the politics of how we need, knowing this information, we need to act.
And can you say a bit about the logic behind the pushback? Do you read it as being about a kind of a desire to just not have a particular state's their own conduct known, or is there something else going on here as to why this hasn't been embraced as a good way of understanding the contours of the problem?
You know, that is such a complicated question because it involves so many different factors. There are times, and Syria is really the primary example, where 600 hospitals have been bombed by the Russians and the Syrian regime. And it has been well known over the last decade of the war. And in that case, the problem is the lack of any accountability. And we saw, I don't know how many times Russia has vetoed referrals to the International Criminal Court for war crimes in Syria. And that has to do with the structure of the Security Council, which is a whole different subject, but it's a huge issue. So we have, where there has been recognition, we've had structural and political problems in gaining some form of accountability, even when there are violations. Second, this resistance on a major issue, that is wars conducted by proxies or partners. I mentioned Yemen and arms sales by the United States before. It was very known within the first month of the war back in 2015 that the Saudis were not targeting properly and many civilians were being killed, hospitals were being hit, and this went on and on and on, and yet the US and the Brits were providing billions of dollars of arms to the Saudis. And you can make an argument that that violates a very specific requirement of IHL, the obligation to ensure respect of the conventions, not only by yourself, but by other powers. The US has taken a very narrow view of that obligation. It also narrowly interpreted arms sales restrictions, as did the British. So we have major powers who purport to be deeply committed to the Geneva Conventions, but when it involves acts by their allies or countries that they have important diplomatic relationships with, they resist taking action that could make a difference. So that's a second issue, that there is resistance to some of these fundamental protections, or narrowing them to limit them to one's own forces. And I've already talked about the problem with enemies. So there's another area of resistance. So we have this combination of inaction when the violations are recognized and cases where the law is twisted a little bit to avoid obligations.
Let me ask a question now that is more focused on, particularly on law students, but also on scholars. I'm wondering first, and my apologies, I've asked a number of compound questions, which is in violation of the rule of interviews, but hopefully you'll forgive me. It's just because there are so many interesting topics in the book to discuss. First, what do you wish that students studying international humanitarian law and law applicable to armed conflict today would think about differently or would do differently than generations before? And second, and related, what do you think a scholarly agenda looks like that takes account of the issues that you raise in the book? So do you see that there is space here for academics and scholars and researchers to also add to the political and the legal agenda that you are seeking to build?
I think there's a ton of work in both areas. And the reason there's a ton of work is because there's so little done. And I think what we really need is a partnership between social scientists and public health people on the one hand and lawyers on the other, because in the social sciences and public health worlds, there's a lot of fear or reluctance to even think about IHL. It just seems too complicated. And we need that partnership to tease out what the violations are, why IHL is so important, why the empirical findings are relevant to IHL. And there's so little work being done. In fact, we did a literature review on peer-reviewed papers over the last 40 years that had talked about violence against healthcare. And there were like 3 dozen in 40 years. And so the need for scholarship and activism and partnerships between law students and lawyers on the one hand and these other communities on the other is just overwhelming. There's just such a lot of work to do. And I would encourage students who are interested to get involved and start writing some analyses of various conflicts. We talk about it in a general sense, but let's talk about the behavior of special forces in Afghanistan, or even the Taliban, which is a fascinating story about the way the Taliban were somewhat restrained and the influence of human rights organizations on the Taliban, or the situation now in Myanmar, where you get human rights issues involved as well as IHL because it's not an armed conflict, but the medical community is the target of the regime. The COVID response in Myanmar has collapsed. Getting into these specific conflicts will enable us to learn so much more. I see my book as one which in 10 years, people will say, oh, Rubenstein was all wrong. We've gone into the real academic studies, and now we understand this better. But I wrote it because I want to kind of stimulate that. I can't overstate how much work there is to do, and having lawyers and law students involved in this would be tremendous.
I think that's such an important message for students looking for research projects, but also for scholars. Part of what I hear you saying is the law as applied and really understanding the way state practice is being shaped on these issues is critical for being able to have an informed conversation about IHL, and really sort of honors some of the incredibly brave people that you profile in this book who are risking their lives every day to provide the kind of care that they are providing, often in conditions in which they themselves could have had a chance to escape, but they remain so that they can continue to care for patients in truly unimaginable situations. And for those who have decided to study international law because of a commitment to justice or a concern for those afflicted by armed conflict, I think your advice and particularly the latter half of the book really give a model, I think, of how to think about your role as an international lawyer, even a very critical or skeptical international lawyer, in a way that is connected to the kinds of situations where this law is being applied today. With that, let me see if there are any questions. Feel free to raise your hand and I will call on you to ask your question live, or I can present questions from the Q&A. So I have one question from the Q&A. I'll start with this, and it is an anonymous question. and then I'll turn to the participants. So the question is this: how would one address the belief if we hold our government to a higher standard, but our enemies hold themselves to a lower standard? We'll certainly lose this war. Should we choose to lose this war, if that means that we can hold on to our morals, or when should practical matters displace our morals? Really, I think an important question, because those of us who work on these issues, I think, do encounter this logic. What do you do when the enemy, when the adversary is not applying the rules and is indeed behaving in such a manner that increasingly there may be those who say, we have to limit the extent to which we restrain ourselves so that we can vanquish this adversary more quickly? How do you grapple with that argument?
It's a great question. I just want to go back to your prior question first. I think the work PLAC does is really a model. The work you've done on counterterrorism, for example, is an example of this kind of link between the facts on the ground and the legal work. That argument is a fairly common one. The idea that in asymmetrical warfare, where the one party shows contempt for the Geneva Conventions, you might lose, as the questioner said, you might lose. There's really no evidence, first of all. I've not seen any evidence where complying with the law causes you to experience a serious military setback. It might take longer to do it in a way that complies with the law. A simple example, you can level a city or not level the city, but you could still prevail. And I don't think there's much evidence or any evidence that compliance with the law has that cost. And of course, it's been a principle of IHL that the fact that your opponent doesn't comply doesn't excuse you from complying. And we have much evidence to the contrary, that you can still prevail when you have complied. And so many of the violations take place in a context where it would be relatively straightforward to comply. For example, checkpoint practices. It's estimated that more people die from not being able to get through a checkpoint than in a hospital bombing. Yet, we've seen plenty of cases where militaries do figure out how to efficiently get people through checkpoints without jeopardizing their security. So it can be done, and we don't really have examples where that kind of cost exists. But it's also a matter of values. It's like torture. If the argument, does torture work? And if it does work, is it justified in certain cases? Well, we say no, because number one, it's a slippery slope. And number two, we have values. And these values are really important values. And we lose a lot when we lose those values.
Okay, I have one more great question in the Q&A, and then Shirley, I'm going to come to you to ask your question live. A question for Patrick is, should healthcare providers and humanitarians be involved in the documentation of violations or violence against healthcare? Is there a tension with the principles of neutrality?
First of all, I want to compliment Patrick Vink on all the wonderful work he's done in this realm.
Agreed.
There are a couple of questions embedded in this question. One is about reporting. I don't see any problem, except a security problem, with healthcare providers reporting, sometimes anonymously, sometimes without revealing their coordinates, in gathering this information. That seems completely consistent with the role they occupy, that they are not speaking out publicly, which could violate their neutrality by taking sides in a conflict. But simply reporting violations seems part of the job of a healthcare provider to protect their staff and patients. So I think it's imperative to report. The question of neutrality, which I also discuss in the book, is an interesting one. There's a myth out there that health professionals should be neutral in the same sense that Switzerland is neutral, that they don't take sides. And humanitarian organizations have a code of conduct for themselves that they're supposed to be neutral. They're not supposed to take sides. Although that's usually an instrumental belief as opposed to a moral belief. That is, it gives them access, it enables them to engage with all groups, it provides security for them by not being subject to attack because they're on the side. But the problem arises when health providers get involved in politics. In Myanmar, for example, where they have led the civil disobedience movement there against the coup. And people say, oh, they're violating their role. They're not neutral, they're not protected. The Geneva Conventions were amended 100 years ago to eliminate that idea. They have to be impartial. That is, as we talked about before, treat everybody equally. But they are not prohibited from having political positions. I mean, think of a military medic. That medic is part of a military organization that's fighting the other side. So they can't be neutral. Or Syrian doctors who are being bombed, you can't expect them to say, oh, I have no views on the people who are bombing me. In their medical role, they should be impartial, but they're entitled, like anybody else, to free speech and can demonstrate or do anything else they think is important, so long as they act in accordance with medical ethics. So I don't see a problem with political action when they feel it's necessary, so long as it doesn't compromise their political role, their medical role. And unfortunately, that's not well understood. They always have to take into account whether going public is going to make their work more difficult. But that's a different question.
Thanks for that answer. And I'm aware that we're running out of time, but I'm going to come to Shirley. Shirley, would you like to ask your question live? And then we'll close the event. Over to you.
Thank you, professors. My name is Shirley. Thank you so much, Professor Rubenstein, for the fascinating explanation. I would like to pick up on your point on WHO data for tracking purposes. While I totally agree that collection of such health-related data is so critical to assure security of effective and impartial health care in armed conflict areas, I was also wondering, how do you deal with dilemma experienced by the healthcare personnel themselves? For example, they are faced with international human rights violations, humanitarian violations at their daily basis, but at the same time, they are obliged to report, to be transparent, to be the source of information to every single violations that harm them in the first place. So how do you make sure that while they are providing the data, data-oriented testimony in this case, at the same time, they also minimize their own risk to be threatened in the long run? How do you make sure those two can coexist together and they are protected while protecting others? Thank you.
Sure, that is a good question. And I think it's one we have to take very seriously, that we have to make sure that reporting is done in a safe way that doesn't jeopardize people. That's why I said a moment ago, sometimes you don't give the exact location. Or certainly the reporting to WHO does not reveal who the reporter is. And they don't actually even reveal where it happened or any other details. So you have to make sure that security remains paramount, but we've seen that there are ways of doing that.
Wonderful. Thank you so much, Professor Len Rubenstein. Let me, on behalf of HLS and on behalf of PLAC, let me thank you so much for this. I really enjoyed talking to you, and I think we all benefited from hearing you talk more about the book. I'll encourage everyone to read the book and seek out a copy of their own. And it was really such a pleasure to talk to you about this important issue.
All right, thanks so much for having me.
Thank you. Bye, everyone.
All right. Bye-bye. Bye-bye.